Hi everyone, and welcome back to this channel for the experts in law, compliance and technology. My name is Tony. We are in Sumsub's London office, and today we have a meeting, let's say book lovers meeting, with our fantastic guest, which is Charlie Kerrigan. He is the partner at the CMS global law firm and the author of amazing books on the cutting-edge technologies and the legal aspects of that, which is the AI, law and regulation, and crypto and digital assets, law and regulation. And we're going to discuss these books, and we're going to discuss the issues related to crypto and related to AI in this meeting. Welcome to this channel, Charlie.
Well, great to be here. Thanks, Tony. We're often remote, so it's good to be here in person.
Yes, as always. These days, a lot of remote stuff happening. It's good to have in person. Charlie, I want to introduce you a bit. Charlie is a partner in CMS, a global law firm. He is the very well-known expert in crypto and AI and related areas. He is the author of several books. One of them is here with me. It's called Crypto and Digital Assets Law and Regulation. Fantastic one.
Thanks for the plug.
Yeah, it's a treatise. And the second one that I don't have is AI, Law and Regulation. By the way, why it's Law and Regulation?
Yeah, sure. Well, I guess we try and be as complete as possible in looking at this. If we talk about law, we're referencing the cases establishing that crypto assets can be property. And when we look at regulation, this is the kind of things that local regulators are permitting or restricting or giving licenses for. So law is the fundamentals, and then regulation sits behind with permissions.
It's like theory and practice.
That's a good way of putting it, yeah.
So we're going to talk about crypto. It's number one. AI is number two. I can tell you I read the book, and this was one of the reasons why I came up with the idea to invite you to discuss this. It's a fantastically written book with the collaboration of various authors. So it's like the calibration as it should be, with many experts. Almost like when I thought about this the level of collaboration, I was thinking about this famous movie Ninth Gate, where you have the Satan together with the collaborator writing the book about the nine gate to the kingdom of shadows or something like that. And here it's the kingdom of crypto,
exactly,
which is almost the same thing in a way. We're going to talk first about crypto. UK is one of the renowned places, like let's say very famous place. Let's say it's like claims to be the global hub for crypto. So on 11th of September, the UK government has come up with the bill on property and digital assets that has been submitted to the parliament. And how, in your opinion, this will change the role of the UK in the global crypto economy, global crypto industry?
Yeah, well, it shows government support, and more than that, it shows support even though we had a change of government. So the original bill builds on the work of the Law Commission. So there's fantastic underlying work in a consultation and then a final report, which are downloadable, an amazing resource. And the previous government looked to take forward the proposal to have this digital assets bill that gives legal certainty, and the new government is taking it forward. So what's the value of legal certainty? We know that crypto grew up without that in the early days back 2008, 9, 10. It wasn't something that got much attention from lawyers, policymakers, governments. It lived on the outside. The fact that it now gets that attention tells us that it's meaningful on a global and policy basis. To have the legal certainty means that if any cases come before the court, the judges have got something that they can point to and say, this tells us that we can find crypto assets are property.
Right. This is one of the things. Yeah.
So property rights give rise to the ability to enforce. If someone steals your property, you want to have a legal remedy.
Yeah.
That would be criminal. If someone breaches a contract relating to crypto assets, then in order to take that right against the person that has breached the contract, you need to be able to have the court say, we recognize the subject matter of the contract, and everything flows from that. So we were probably there anyway, the UK judges are very smart and sophisticated people. I think it's obvious that crypto assets are property because commercial parties treat them as property. They buy and sell and trade them, and they pay money for them. So we'd be in a difficult situation analytically if lawyers weren't able to say that the law was recognizing them. These are novel kinds of assets, so they don't fit into obviously established categories.
Tangible, intangible.
Exactly, yeah. So obviously not tangible. You can't touch crypto assets. And then I think the natural assumption is that then they would be intangible assets. But lawyers are categorizers. You're a lawyer, you know this. And we've categorized intangible assets using the categories that we've grown up with for decades.
Yeah.
So the best example, best known, is intellectual property.
Right.
Crypto assets aren't intellectual property because they're established by legislation. We have copyright in the UK because the Copyright Act says we do. Things that meet the conditions of the Act are recognized as copyright. So crypto assets are not that.
Well, they're pieces of the code. You can say that the code is kind of like a literary
That's right, for
piece.
sure.
So this means in some way it's a copyright, but it doesn't definitely describe the whole nature of crypto asset as a financially driven category, for example.
Yeah, well put. So I think that describes part of the issue that we have, that copyright automatically arises in relation to code when it's created by a person, and we might come on to non-person creators of what appears to be intellectual property.
Yeah.
So we've got copyright rights in relation to the codes, but crypto assets are more than that. If I'm transferring a Bitcoin to you, I'm not transferring the code because I didn't write it. It's open source.
Yeah.
So that's not the subject matter of our trade. The subject matter is the
underlying value behind it.
So what we'd call the crypto token, which has got that underlying value. And it reflects the fact why we're probably on to the point here. Every regulator, the SEC, accepts that Bitcoin is not a security. And we're touching on the reason for that here. There's no issuer of Bitcoin. There's no ability to redeem it. You can trade it. You can buy it and sell it. If you want to get your money back, then you can sell it. You hope that you're selling it for the same or a higher price, but you can't redeem it. There's no Bitcoin issuer that will give you your money back in the same way as a kind of regular commercial third party.
I can just remember one of the nice phrases that I saw in the book, which is like one of the premises of the whole idea of the book, which is that crypto copied everything in finance and made it available to mass market investors, which is fantastic. Also, I love another thing, which is also in terms of the property, like the finger of God. In Michelangelo, the creation of Adam in Sistine Chapel, computer code creates property, which is fantastic.
I must have been writing that bit late one evening.
No, it's just fantastic phrase. So tell me, this means basically that we have everything that we have in traditional finance, in traditional assets. We should have, or we have already do have in crypto, such as property rights, things like security interest, security deposits, etc., floating charges, trusts, etc. Does it all exist? Because I know that the audience in general consider crypto is either the matter of payment, usually when it comes to stable coins, or a matter of, let's say, investment in a way, or a matter of tax evasion, for example. But it should be more of things.
Yeah, crypto does lots of different things, and I think we should also clarify the distinction between the unbacked crypto assets, so assets like Bitcoin, ETH, which have no existence other than the code and the fact that they're traded, versus the fact that we are now seeing traditional financial institutions and central banks tokenizing, i.e. creating crypto tokens representing traditional financial assets. So we've got bonds that are tokenized. The European Central Bank has been issuing bonds, so experimenting. These are relatively small issuances compared to the size of traditional transactions. But the benefit in doing that is that we've got the advantages of digitalization, automation, efficiency, fewer issues with reconciliation, because everyone's looking at the same ledger.
Yeah.
If you look at a traditional transaction, you've got multiple parties.
Yes.
They've all got their own ledgers. To the extent that there are differences on the ledgers, then it could give rise to disputes or potentially litigation ultimately. So less scope for disagreement, less scope for human error, all of these benefits that flow on from the assets. I guess we should, looking back to the point that we made around regulators, so one of the hard points of crypto is it's money on the internet.
Yeah.
So naturally, it can exist everywhere cross-border. Regulation is domestic. So the regulators have a hard problem here, which is people outside their jurisdiction are able to make available crypto assets to people inside the jurisdiction. So how do you protect consumers in your jurisdiction when these things are accessible generally on the internet? That problem is solved by regulation and licensing of centralized exchanges, more difficult in the case of decentralized exchanges. Yeah. So we've got a spectrum of true DeFi, which is purely peer-to-peer. Regulators not going to interfere with us just entering into personal transactions, centralized exchanges, and then the traditional financial markets that are going through this tokenization experiment, building on the benefits of the technology to improve existing markets.
So right now, can we say that, let's say I have a firm in the UK, someone else, my friend has a firm in Brazil. Obviously, it's very hard to get into Brazilian financial system, as probably many people know. I mean, it's a very closed up system. So can we, for example, have a contract in which the tender, the payment method will be crypto? I will pay in that amount of USDTs. And this will be under UK law, this will be perfectly legal.
Yeah, sure. So no problem under UK law. We have freedom of contract, and the parties are free to agree among themselves what the bargain would be. So if you're giving me something of value and I'm paying a crypto asset for it, that doesn't have to be legal tender. It's completely open to us to enter into a bargain where I'm paying you something that you think has value. Yeah. In exchange for something that I think has value. It flows into the question that we started with of if the crypto asset that is being paid between us isn't property, and maybe some questions around how we get to enforce that if we go to the courts. Hopefully we don't go to the courts, but that again explains why recognition of crypto assets as property under English law supports the fact that parties can enter into bargains where one side or both sides of the trade involve crypto assets.
And they can, for example, put in the dispute resolution clause, for example, some kind of an arbitral tribunal. And I guess for the arbitrator, it will be much easier to accept this as a perfectly legal thing to do. I have seen some of the venture finance transactions, including, let's say, investment contracts where, let's say, the investors actually invested not money, they invested digital assets into the companies, and it becomes more and more typical.
It does, and it's not difficult to write in the contract. So if we are assuming in that case that we've got a natural language contract, so it's a sale and purchase contract, where we might have a traditional reference to an obligation on the buyer to make a payment of a certain currency to a certain identified bank account. In that case, we're doing basically the same thing, but the currency is crypto token and it's a wallet address rather than a bank account. Right. And the transparency of the ledger means that the parties want real time, not going through a bank. And the transparency of the ledger means that you can see that your funds have arrived, and both parties see that at the same time. So it's somewhat unnatural to people who are not working in the space, but I think if you're in the space, you can see the benefits of transparency and evidence there.
Yeah, you can watch, for example, in Ethereum, which is the most typical, I guess, ecosystem. You can see everything in Etherscan or Tronscan, if it's Tron part of it. What I wanted to discuss is decentralized finance. I have actually some of the let's say friends or let's say colleagues that have decentralized projects, and they are themselves quite unsure exactly what they are. Other, let's say, some kind of an entity or not, or is it some kind of an association, unincorporated association, or partnership, or nothing.
Yes.
What is right now the general approach, for example, in the UK? How would you advise projects like that?
Sure. So the fundamental question, we use the phrase sufficiently decentralized. So if you have a conversation with three founders and they say that they build a DeFi project, but they control 100% of the decision making and the tokens inside that project, then not decentralized. So it's fact dependent. At the other end of the spectrum, we can say that Bitcoin is the clearest example of a decentralized project. It's obvious that nobody is controlling the chain.
Yeah.
So it's always a spectrum. There's an open question about how much support jurisdictions could provide. So a lawyer may say it would be valuable for a local regulator or a local policymaker to define decentralization, to put some numbers around it, the level of nodes that are operated or the number of people that are validating transactions. Difficulty with that is it provides certainty, but perhaps it boxes things in, or it gives the ability for projects to game the rules. So you can see what would be just the other side of the definition of decentralized, where really projects should be aiming for the greatest amount of decentralization. So I think, like everything in crypto, people are figuring out how that works. The implications of your point, you know this because we've looked at this before we have this conversation. If a project isn't sufficiently decentralized, then it's something else. So a local lawyer will say, well, that looks like a partnership, or it looks like it's not a company because it's not registered at the company's registry, but it's an unincorporated association, might be the version of that we use in the UK. So we talk about lawyers being categorizers.
Yeah.
You always put a category around something. Yeah. If it doesn't meet the test for decentralization, we're looking at it the other way around and saying, well, it's something else then.
Another part of this question would be the tort liability. It actually has a value for AI part as well. So for the developer of the code, especially when the code is written open source, now should be all the time afraid of being held responsible for the code as a liability issue? Yeah,
so certainly having that in mind, a supportive legal system would not impose those liabilities. So I think this is a good example of where we need to make the distinction between, say, traditional finance, where a traditional financial institution has fiduciary duties, particularly to any retail customers. Does that read across where the writer of a code has got duties to people who are using the code?
Right.
In open source projects, I think open source can't flourish if jurisdictions are going to put that liability on them. So I think it's important that judges and policymakers recognize the value of open source, that they're not saying crypto's open source, we don't like crypto, so we don't like open source. We don't want someone to mistakenly end up shutting down GitHub and all of the value and benefit that comes from that. So a lot of this is about education. And I think once policymakers understand that crypto is part of a wider ecosystem of open source development, tech development, the talent that all jurisdictions are competing for in this area, it tends to get more information helps in these circumstances. Right.
Another issue that is very interesting is, of course, smart contract. This is something that was, impossible or unimaginable outside of blockchain. Now we have this thing in place. I love the phrase that you have put in the book, which is the code is a law or law is a code, so it goes both ways, I guess. So how do you think this idea of smart contract, how it may change, let's say, conveyancing in general?
Maybe use conveyancing as an example. Smart contracts we define, or the technical people would define, as something which is self-executing code. And so this is where the code as law comes from. It's not as simple as that. As a lawyer, we'd say, well, that means that it can have the characteristics of a contract. It can, in the case of us trading assets between ourselves, we could do that on chain. We could use the Ethereum virtual machine and have the same effect as a legally binding natural language contract. Contract law hasn't changed. So under English law, a contract has still got to have certain characteristics. It's got to be between parties that intend to enter into legal relations. It's got to have some
consideration,
bargain. Exactly. So we got the list. A smart contract may or may not have those characteristics. If it does, it's recognized as a contract. If it doesn't, then it's something else. It's a piece of code that executes and may transfer value. So I think it doesn't need a bright line between the two.
So they intersect sometimes they...
Exactly right, yeah. So I think from a party's perspective, as long as you know if you intend to have legal remedies, then be mindful of the fact that the smart contract has to have these characteristics. If you're not, if that's not a significant thing, you're comfortable with the counterparty, you're comfortable with these simply being coded relationships. So you've got collateral for the trade, and so if there's a failure of one of the counterparties, you've got recourse to the collateral that's posted in the smart contract, then you may be fine without needing to go to court.
It seems in general that this approach in the UK, especially, I mean, obviously what you're talking about is specifically related to the UK, sounds like a very liberal approach. We have other examples. One of them being the United States, where like for a number of years, last like couple of years, we have had like bad news one after another. SEC has been just basically grilling the major crypto platforms. We had a claim against Binance, we had a claim against Coinbase, we had actually a claim against Ripple, which was found the other way around, was in favor of Ripple, but it was specific things there inside that kind of like saved them. But in general, we see that the approach of the SEC is very harsh. They basically they just use this securities law. They have how you test that basically limits any entrepreneurial opportunities in crypto, because you need to register with the SEC and you need to hire lawyers for that, and you need to lots of stuff. And so basically this ends up the whole idea if you want to do something in the US. And this relates to everything, including even probably Ethereum, but at the same time excluding Bitcoin, because Gensler himself, the chair of SEC, said that Bitcoin is not a security. Everything else probably is. And Gensler has been grilled quite recently in the Congress, specifically, I guess, like a week ago, from the Republican side, and we will see where it goes. I guess that's part of the political struggle there right now. What do you think about the future of crypto in the US, for example, and how it will affect the global economy?
Yeah, well, it's become a political issue, and we see prediction markets making predictions about the price of Bitcoin depending on who wins the election in November. From the perspective of the SEC, they're making points that are pretty customary from a regulator. So what they're focusing on is consumer protection, and that relates to, in particular, the type of disclosures that are required. So they're saying if you're fundraising and issuing something that has the characteristics of an investment, well, we've got rules for that. You need to have a prospectus that walks through the business model, the risk factors, the characteristics of the investment, and so on. It's conventional. It's logical that they would say we shouldn't have one set of rules for transactions that are happening in TradFi, a different set of rules for transactions that have the equivalent effect and potential for the equivalent consumer harm in crypto. I think the key parts about the cases is they make new law. So as each case goes by, you're calling them out. We've got more clarification on where the lines are. There's clearly some likelihood that from January, we've got a different policy in place in the US. I think the US is going to be a center for crypto regardless.
It's a huge market.
The money's there, the talent is there, the entrepreneurial spirit is there. I think the most amazing thing about where the US is, it's, as you say, it's very well known that they're working through these kind of teething troubles with regulators and legal claims. The fact that the US has made so much progress, even in that environment, I find so encouraging. And with more support, which I think is inevitable, it is going to be a huge industry in the US, even larger than it is now, and that will have implications across the wider economy.
What I'm thinking about is that the UK can actually use this as an opportunity time, to open up its economy for the projects. Obviously, US and UK are very, very closely connected in terms of the economies, and you can easily, for example, use the domestic jurisdiction in the UK to welcome all the projects that are otherwise working in the US to be registered here, to have like the main office here, to be regulated by the UK law, and at the same time to have some operations in the US. How do you like this idea?
Oh, yeah, I'd love to. So the UK has always been one of the routes for international expansion, European expansion from the US. Brexit complicated that. So we'll see over the next few years whether a new government is going to make it easier to access European markets from the UK for financial and technical issues. Going back the other way, it's difficult to expand into the US, not only for the reasons that we've described, but there are 50 states, there are federal laws, different kinds of regulators. So it's generally only worth going to the US when you've got a certain scale. You break into a market at scale, then it's valuable. I think the UK, I mean, we're sitting here in London today, so we're referencing the UK, but both of us, as we work together and as we work with other clients, we're looking internationally. I think crypto is, by definition, international business. There are local specifications for different types of projects, whether they do require a license or don't require a license, the way that you go to market, marketing rules and similar. But the clients in both our cases expect us to have the broad global perspective. We're often asked the question, where's the best place to launch? Where's the best place to locate?
Yes.
How do we expand across different jurisdictions? Because, as we touched on before, people have got the advantage of the internet is a global distribution channel. How do you take advantage of that? With the regulators saying, safely. Yeah. So it's putting the two together.
Yeah. Let's jump into AI. AI, I mean, we have, even Sumsub, we have lots of issues related to AI. We have AI-powered parts of the product. And sometimes it's clear that the columns of ethics that we all know, such as the explainability, robustness, they are nice to have. I mean, obviously, these are all good things. But sometimes it's really hard to say how to implement this. And the people that will watch us probably the audience will include the people who are actually developing AI, and they know that sometimes if you want to have a robust AI, it's really hard to make it explainable. Because if it's explainable, usually it's a stupid AI, if you can explain it. What do you think about this problem?
Yeah, so there are trade-offs. I think we see in the academic and technical literature that there are some more optimization can lead to less explainability. Yeah. It depends on the nature of the task. So I think if we're looking at using it in any connection with financial products, financial regulators expect financial firms to be able to explain why a decision has been made. So if that has been with the support of some automated system, you've got to have a read through to the system in order to be able to satisfy the regulator that you can justify your decisions. That's not necessarily the case with lots of things. So a recommender engine, you lose nothing as a consumer if you watch the first 10 minutes of a film you don't like. So regulators are less concerned about that.
Well, it depends. When we're talking about, let's say, Digital Services Act in the UK, in the EU, it says specifically about the recommenders engines and about the what is called the dark patterns behind the scenes, etc.
Yeah, that's a good point. So I think dark patterns are problematic. I guess the kind of classic example of where there are problems with that is people trying to unsubscribe. So it takes us, I think, to the core of AI use from my perspective, and it picks up your point around ethics, which is if businesses focus on using AI to improve outcomes and services for customers, you're unlikely to go wrong. So if you're using AI in favor of the business and against the customers, then a regulator will naturally view that as problematic. And we can see how the EU, the Commission, through its AI Act, it's now going through the implementation phase, they took an interesting approach. So that is based on product safety regulation, and it's risk-based. So it has a huge net that picks up any type of AI, including things that would not be thought of by AI scientists as AIs. So things that are just algorithmic, autonomous decision-making. So it's saying, let's throw the whole net around all of this on the basis that if we're doing risk classification and the systems are low risk or minimal risk, it's fine, keep going. But we're pulling out uses of autonomous systems that are either in the prohibited category, so that tends to relate to manipulation or subliminal tools, subliminal techniques, exactly. So I think we're kind of honing in on the points, as you used the reference to where regulators would be concerned about these things, and there's an obvious theme which the EU Act calls out. This is intended to support European values, human dignity, human values. So they've got a real theme sitting behind that. And I think what they're saying is make the tools work on behalf of people. And so that's reflected in human in the loop oversight, and also the fact that they are prohibiting things that look like they have controlling aspects. And that relates not just to companies, but they're focused on law enforcement, states. They don't want state surveillance. They don't want state control of populations.
In the EU AI Act, they use what you have actually already mentioned, subliminal techniques, purposefully manipulative or deceptive techniques, materially distorting the behavior of a person, of a group of persons. Do you like this language?
Well, I think so often people focus on the first bit about subliminal techniques, and I think we got to look at both sides of it. So the second part is this reference to, and there are 3 or 4.
They just say, in my opinion, when I read this, it just sounds like evil.
So it's the outcomes based that I think is good to keep in mind at the same time. So it's getting people to do things that they wouldn't do if they had more information or were given a free choice or weren't being driven by an algorithm down a certain way. So this is trying to avoid systems making people do things that are not in their best interests, or they haven't been able to make a free choice in relation to them. So it's in part that an AI tool is not in itself good or bad, it's the use that you put it to. So what the regulators are trying to call out is both the techniques and the outcomes. So that outcomes and purpose is a significant part of it. When we're talking to clients, that's the bit that we're also trying to focus on. What is the system doing? One of the complications of doing reviews of the systems from a regulatory perspective is that the same AI system can be completely harmless. It can be doing something that is like a co-pilot, just supporting someone in their work. The same system can equally be providing bias or manipulative results. So when we're talking to firms about their model inventory, we can't just go down the model inventory and say, this one's prohibited, this one's fine, this one needs tuning. We're saying, this one, what's it doing? In each case, what's it doing? And probably worth calling out for the audience, and the first deadline we've got for the EU AI Act is February 2025, where prohibited systems must be switched off. So everybody now who's touching European consumers or European markets should be looking at their model inventory and
should be looking out for a lawyer. Would be CMS, for example.
That too.
And yeah, it's not much time left.
Yes, exactly.
Yeah.
The countdown's on.
I just in terms of this distorting, what they say, manipulative, deceptive techniques. I just remember, maybe you remember this viral video. It was Yeni Laurel. When some people, they listen to it and they hear Laurel, and then somebody else listens to it and they hear Yeni, and it's just one in the same video.
We had similar things with the dress. They could be blue
dress,
or gold.
yes, golden or blue, deep blue. Yeah. So this obviously is just a just a joke, but
there's an interesting relation between manipulation and financial regulation. So financial regulation is often principles based, and one of the key principles is that customers are treated fairly and they get good outcomes. So you can see the read across here from the AI Act. It's saying focus on outcomes of the algorithms and autonomous systems and check that they are operating in the interests of customers. So often if we're having conversations with fintechs or banks and saying, you've got a lot of this already, so they're concerned about how they can get ready to comply. But a lot of what the Act is trying to drive behaviours towards are benefiting consumers. Financial regulation's already looking at that. So in some ways it's easier for financial firms to comply because, well, one, they've been regulated forever, and two, they're already focused on customer outcomes. So we're trying to get non-financial firms to think to some extent like banks and financial firms.
Another topic that I think is very hot, and again, I hope that part of the audience will be the developers, and they are concerned about this, which is the patenting or copyright in AI. And of course, one of the aspects of that is, for example, you created an AI and it developed some code which actually is an invention, and it's a famous thing, quite recent one, DAOs case, where basically a DAOs, which stands for Device for an Autonomous Bootstrapping of Unified Sentience. It was an AI system, basically. It created some kind of an invention, and the idea was to patent this invention. And in different countries, the result was different. In South Africa, the patent actually was granted. And here in the UK, I think, again, quite recently, it was denied because they said that the inventor should be an entity with legal capacity. Although, if we return back to Roman law, for example, you can imagine that, for example, a slave has created something, and then the owner of the slave can become the owner of this thing because of the usufructus law. So in some way, we can make some kind of a fixture, or let's say a fiction, saying that, well, it's it's kind of like a slave, and we can just refer to the owner of the code, or owner of the AI. What do you think about all of this?
We're going to see a lot more of this. So agentic systems are a big and growing thing, and so we've got the question, as you say, in the UK, we got that decision. It relates more to the language of our existing legislation for patents. So the UK Patent Act has that reference in it, as you say, that the assumption of the people drafting the Patent Act a few decades ago was that it would be a person who was creating these innovative new products or tools. So it wasn't in the minds of the draftsperson of the legislation that there could be a non-natural person which is producing them. So there's a policy question, which is, should it be permitted for AI tools to be credited with inventions? And then following from that, if the answer is yes, it's not a difficult change to update that existing piece of legislation to say it could be a non-natural person, or it could be a natural person or a non-natural person. The question behind it, I think, is AI creative? And I still think mine feels like a minority view, but I think it must be. When you see the songwriter cases about copyright and maybe an infringement claim because a new song sounds something like an old song, and the songwriter's natural defense is to say, well, I was influenced by all the old music. I grew up listening to it. I wasn't copying it, but I inevitably influenced.
It was playing in my brain.
And so in the case of the AI is influenced by its training data, whether it's the internet or private set of training data. So I think the fact that AI, generative AI, it now produces content and it can answer questions in an informative way, that is a version of creativity that would be recognized by most humans in another human. So if you and I are determining whether our work is creative, the fact that it's original because we've produced it, we think is enough. We're not checking it against Shakespeare to see if it meets.
Although everything is Shakespeare, actually. If you look at most of the movies, they're based on Shakespeare.
Well, yeah, there you go. So creativity doesn't need to imply literary merit or something like that. I think in amongst all of the disagreements and arguments about business model for generative AI, it's going to cost $10 billion to train LLMs, and how are people going to get the money back at $20 a month? I think just kind of time out, the computers can read and write. That is huge.
That is really huge, yeah. In terms of several questions still very important for us, we are doing anti-fraud and we are using AI for anti-fraud tasks. And I know that you are advising companies that are doing stuff like that. What do you think is the potential of anti-fraud AI and how it will develop in the future?
So you'll have used AI in anti-fraud for a long time. AI got famous in November 2022 because of ChatGPT, but you guys have used it for a long time because traditional AI is a pattern recognition tool, and fraud identification relies on pattern recognition. I think the most interesting thing about AI in the context of fraud is fraudsters' ability to use AI. So this thing is now let loose. It's available for free or $20 a month. Ability to generate lifelike video and sound of humans trained on a small amount of video means that CEO fraud is much easier to produce. So everyone is concerned about CEO fraud. This is your CEO phones you. Your CEO appears to phone you.
Yeah.
What was needed a while ago was people to be able to spoof addresses and then hope that they were writing in the style of the CEO. Now you've got the person, their face and their voice telling you to send whatever it is, $1 million to this address.
And probably the only way how we can recognize that this is a fraud is to use another AI that would catch this AI. So basically we're in the world of, Terminator, when you have to good Terminators, bad Terminators, just like.
I think that's where we are. Yeah.
What do you think in terms of the development of the AI rules, AI regulation? So we see this example of the EU approach, but again, what about the US? What about the general approaches?
I think it's cultural. So the EU AI Act is classic EU regulation. So it describes itself as balance between innovation and customer protection, but I think most people see it as leaning more towards customer protection. It's values-based, we referenced that already, so it feels like the kind of regulation that you'd be used to in the EU. question whether that will make some of the EU AI development firms feel that it's a harder place to grow their business than, say, in the US. The US is naturally, historically, more innovation focused. It has Silicon Valley and all the other centers of innovation. We've seen proposed AI regulation in California just get voted down, but that shows that different states have got different approaches. One of the early AI laws was in New York, concerned with hiring practices, so ensuring that there's no bias in hiring practices where algorithms are used, and it's one of the places where
male, female, yeah,
exactly, yeah, and different kinds of protected characteristics. It's something that I think often firms who bring us in to help with their AI compliance and implementation, it's not high on the list, but HR departments are pretty much all using AI, unless you're a very small firm.
Exactly.
You've got some CV sifting tools, you've got things that support with employee appraisals and objective setting. So one of the first places we're going is to test those, and they are in the high risk category in the EU's Act. Where are we in the UK? So I think the new government may have a different policy aim than the previous governments. We're waiting for that to be pushed out and released. We know that they're spending a lot of time thinking about it. So I guess UK watch this space, likely to have something in between EU and US. It's my guess right now.
You probably watched Black Mirror, the Westworld, etc., etc. So, what do you think? Should we expect something like that would be our future? Let's say all these virtual retirement homes where people are hanging out in virtual nightclubs, being very young in that metaverse reality.
It's a great thought. Well, I have no qualifications to predict the future. I'd like to think so. I'm definitely optimistic about these technologies. My career has been defined by supporting technical development. It's the most interesting part of my job. Right now is by far the most interesting part of my career, with all the things that we're discussing today and working on together for different clients. So I can't help but be optimistic about it. I think that these are tools that can support a lot of personal and human development, and people will have their own personal AI. It's obvious where the issues are. We've called out around manipulation, and we've already got data protection rules in different places, giving people transparency, the ability to make choices. AIs can help with that. So if you have personal AIs, they can be scanning and telling you, flagging issues where there are things that are inconsistent with how you've explained your values to the AI or something like that. So these should be tools for good. It's not a bad thing that governments and regulators are looking over the shoulder of the developers, but I think in most of my experience, the developers are trying to build things that are valuable for people and would be valued by people. But maybe I'm lucky and I'm working at the right.
Also, I guess that's the time when the lawyers have to be so creative as possible, because we are basically in the time. Part of your book is about the areas where there are no laws
Yes.
at the moment, and we need to create something, come up with some principles based on previous ideas, or maybe just our imagination, or fairness in general, right?
Yeah, we're trying to manage risk, help people develop things that are. You shouldn't have a lawyer that's wants to tell you what you can't do. You should work with a lawyer that tells you what you can do and is trying to support your vision for developing business and revenues and communities and things like that. So I think lawyers themselves will inevitably change. AI is quite a challenge for the business model of traditional law firms. It allows lawyers inside companies, Sumsub has got lots of internal lawyers, it lets them do more because they've got tools. So the challenge for external law firms is, if we are not dealing with some of our flow work is the overflow from lawyers inside our clients, maybe there'll be less of that. So we've got to figure out how we can be supportive in other ways.
Well, I guess that's it. Thank you very much, Charlie, for this talk. I think it was very interesting, really. We have discussed with Charlie that maybe we can make a real live session, for example, with maybe questions from the audience. I'm sure that there should be questions. Please put the questions below the video, and if you want to be subscribed, please push the bell. We definitely will share the LinkedIn profile and whatever you have be below the video. Please buy the book. This is a fantastic book, and to be prepared for the talk with Charlie, you definitely need to first read the book, and the book about AI as well. And thank you for your attention, and see you around. Take care.